The participants, I'm very happy for having given this opportunity to me to speak about human rights, and especially my focus will be on international human rights law and how its parameters or standards are laid down in international human rights instruments, and also how those standards or parameters as are laid down in international instruments, you see, would impose an obligation upon states so that the states would have to, in their constitution or ordinary laws, will have to comply with those obligations by providing provisions in the constitution or the statute. Now, this is how I would proceed in today's lecture. Now, the most important thing about the issues that are involved. But before that, even before going to the issues, what is also of importance when we speak about human rights, and especially as I will be initially be concentrating upon international human rights law, what is its importance is that what was the necessity for including certain standards in international human rights instruments so that it would guide all the states. Now, this is an important matter to be considered because that owing to the untold misery, especially miseries caused by the rulers of the states. You see, that was their concentration. Especially I am referring to the Second World War that took place. How during the Second World War, or even before the Second World War itself, in many parts of the world, subjects were faced with these problems of misery, violence, oppression, and other things. Now, therefore, at the time of drafting the Charter of the United Nations Organization, immediately after the war, or even as the war was coming to an end, they were thinking, rather they had already started their efforts to draft an international instrument for the purpose of establishing an international organization. Earlier there was League of Nations, but then it was not working satisfactorily. Therefore, they wanted to improve upon those provisions of the League of Nations as laid down in the Covenant of the League of Nations, and therefore, in the Charter, they thought in terms of providing certain terms which would be an improvement upon the Covenant provisions. While the Covenant of the League of Nations was essentially focusing upon prohibiting war, although it could not do so in clear terms, that was not enough. That was how it was thought to be. Apart from prohibition of war, the causes of war also should be eliminated. Now, it was for this purpose that in the draft or in the Charter itself, ultimately when the final draft was prepared, you will find paragraphs 2 and 3 of Article 1 of the Charter, which emphasizes upon friendly relations among states in paragraph 2, and also cooperation among states in paragraph 3. Now, while stressing upon cooperation it also provides for protection and promotion of human rights. That is what you will see in paragraph 3 of Article 1 of the Charter of the United Nations Organization. You see, that was how the word human rights was first used in the Charter of the United Nations Organization. For earlier, it was known to be basic rights or natural rights and so on. In fact, natural rights is a history right from the period of Greek civilization, and in the Charter, therefore, when they envisaged about the protection and promotion of human rights, they thought that elaboration in respect of human rights by providing contents of human rights was necessary. It was not provided in the Charter. Our Charter only made mention of human rights, but there was nothing about the content of human rights. That was how the Charter of 1945, which could not give the contents of human rights, in the year 1948, the General Assembly of the United Nations Organization adopted a resolution called Universal Declaration of Human Rights. You must all be knowing that General Assembly can only make recommendation. The Universal Declaration of Human Rights technically is only a recommendation, and therefore it is for the states to provide for those rights in their constitutions or legislation or in ordinary laws, so that the promotion and protection of human rights can prevail all over the world. That was how it was thought to be. But unfortunately, it did not happen. Violations were taking place still, and therefore they thought in terms of providing certain or bringing about certain treaties or what you call conventions on human rights. Convention on human rights had to be thought in terms of imposing obligations upon states, because they found that Universal Declaration of Human Rights only became a guidelines, and states were not seriously looking about the provisions of the Universal Declaration of Human Rights. So they started for the provisions, they started drafting the provisions of human rights. Now they wanted a Bill of Rights. A Bill of Rights providing for all civil and political rights, and also economic, social and cultural rights. But there was difficulties, because soon after the Second World War, they started Cold War. And the Western states, led by United States of America, they were giving prominence to civil and political rights. Whereas socialist states led by USSR, they were insisting upon economic and social rights. Therefore, it was very difficult to conceive a single bill in which you can provide for all civil, political, economic and social rights. It was a divided world. Therefore, they had to divide the bill itself. There were two covenants, therefore: International Covenant on Civil and Political Rights and International Covenant on Economic, Social and Cultural Rights. That was the only way that they could compromise then existing situation. Because if they had thought in terms of bringing about a single bill, more probably the Western states would not have been parties to that treaty, because it contained economic and social rights. And also, socialist states would not have been parties, because it provided for social and it provided for civil and political rights. That is how they had to divide it. But because it is a treaty, states who are parties have an obligation to see that the provisions of those human rights conventions are applied in their states. That is the obligation of a treaty. Treaty is like a contract. And if large number of states, when they come together and make a treaty, it is called as convention. That is how these two conventions came. Now you will find civil and political rights covenant today has more than 160 states, about almost 170 states are there who are parties to this. So also with regard to economic, social and cultural rights. Thereafter, they thought in terms of more and more number of treaties. The very early treaty, immediately after this, was International Convention on Elimination of Racial Discrimination. And then, of course, there came a number of other human rights conventions like the elimination of discrimination against women, Convention against torture, Convention on the Rights of the Child, and so on. The purpose behind making such a treaty was to see that as many states as possible will become parties to it. So that over a period of time, you will find that because they are parties to the treaty, it will impose obligations upon them, and therefore they will, through their constitutions or through their laws, will provide for these human rights, and protection and promotion of human rights will prevail. That was how it was started. But however, because I don't know whether you have all read international law already. But in international law, when a state becomes a party to a treaty, a state can also make reservations to treaties. Now, what exactly you mean by reservation? Reservation would mean a state, while accepting and becoming a party to a treaty, can seek also exception to certain provisions. That is what is called as reservation. Now, what is the impact of this institution of preservation in human rights conventions? States went on accepting it with reservations. For example, in International Convention on the Elimination of all forms of discrimination against women, number of states accepted it. For example, most of the Islamic states became parties to it with the reservation so long as it is not in conflict with Sharia law. Now, while the object and purpose of the International Convention on Elimination of Discrimination against Women was to provide equality, by making reservation that it would be acceptable if it is not in conflict with Sharia law, the very object and purpose of the convention is lost. Now, this was how, you see, the reservation works. I'm only giving, you see, a broad idea about it. Now, this is how human rights, you see, the history of human rights from the time of starting of the United Nations organization could be seen. I'm not going back because, as I said, right from Greek period we can trace it, but you see, I cannot do it because of the time element involved. Now, coming to the issues involved. Now, how the human rights should be provided? Now, there are a number of authors who have argued what should be the nature of human rights. I am particularly referring to James Nichol, who has written this classical work on Making Sense of Human Rights, Philosophical Reflections on the Universal Declaration of Human Rights, where he argues that rights, that is human rights, for all peoples all over the world. There is no exception. If a state, that is the obligation upon the state is to promote and protect human rights for all people, whether they are nationals or not. That is more important here. Irrespective of their nationality, so long as they are residing in the territory of that state, human rights should be provided. if you have accepted civil and political rights, civil and political rights should be conferred, should be given to all peoples who are residing within the territory. So also with regard to others. Now therefore, but at the same time what also should be noted is that these human rights norms which are applicable to all people who are residing within the territory of the state, you see, and that is equality, concept of equality. But at the same time, there may be disadvantaged people. And therefore, there is nothing wrong, you see, in providing special treatment to those who are disadvantaged. That is also there because it would not affect the concept of equality as it is understood. The second is human rights are universal. Of course, it is a big controversy that is going on today with regard to universality of human rights. The idea here is that these rights should be universal. Universal because what is accepted here as human rights are basic norms, basic standards, and they should be applicable to all people, and therefore there should be no distinction, no discrimination. It should be universal. But however, there is also a controversy, as I said. The controversy is that rights should always be subjected to the cultural norms of the particular society. That is how you see cultural relativity aspect has also been introduced. Namely, that human rights cannot be universal. There is a big discussion that is going on. Human rights is not universal, but it is culturally relative. It depends upon the culture of the society in which it has to be applied. And the third thing is the precise meaning of the human rights. What exactly you mean by human rights? Now here, the argument is that the purpose of human rights is not to give as much happiness to the people as possible. It is only to provide a minimally good life. You see, that is what James Nichol in his book provides for. Minimally good life. Which would mean that if the state wants to give more protection, they are free to do so. But this is the minimum that you have to give. Therefore, you cannot give less than what is provided in the treaty. That is the meaning of minimally good life. Then, practical perspective of the human rights becomes also very important because there is always a big difference between what is rhetoric and what is real. You have to translate the right into action. And therefore, what is of importance is that these human rights as are provided should reach people. And how at all it could reach people? Through the laws of the state, then through its implementation by the executive, and then if there are violations of human rights, then there should be an independent judiciary to give remedies to the people who are victims of violations of human rights. You see, that is the reason a practical perspective of human rights is being discussed. Now I go to the development in the charter and how the charter would seek to provide for it. Now the greatest difficulty in the implementation of the human rights is that the convention says this is what the states should do. But all states are sovereign states. Now therefore, the problem is, would the states allow such a regime or regime of human rights to be followed by them, notwithstanding the fact that they are sovereign states and therefore they should not be controlled by outsiders? You see, sovereignty is an important aspect in international law, and sovereignty has long back been understood as not answerable to anybody. I am a sovereign state, therefore I am capable of doing anything. And the purpose of human rights is to see that the states would follow these norms of human rights. Therefore, there is a collision, a conflict, a tension between international human rights standards on the one hand and state sovereignty on the other. What is more, paragraph 7 of Article 2 of the Charter of the United Nations Organization provides that United Nations Organization shall not intervene in matters which are essentially within the domestic jurisdiction of state. Now see, that is, domestic jurisdiction concept is nothing but sovereignty concept. And it says, United Nations Organization shall not intervene in matters which are essentially within the domestic jurisdiction of a state. Which would mean, in the early period of the United Nations Organization, whenever the complaints of violations of human rights were raised in the forum of the General Assembly, the targeted states, that is, those who were accused of having violated human rights, started quoting paragraph 7 of Article 2, like devil quoting the scripture. See, paragraph 7 of Article 2 says we can do anything. I mean, you cannot intervene. How can you at all intervene? But this matter, therefore, had to be settled by the General Assembly. Now, General Assembly did not succumb to the arguments of those sovereign states who were victims, rather who were accused of having violated human rights. General Assembly interpreted the provisions of paragraph 7 of Article 2. United Nations Organization shall not intervene. The word intervene has to be defined, interpreted. It shall not intervene in matters which are essentially within the domestic jurisdiction, not all matters of domestic jurisdiction. Now, I will not go into the technicalities of this interpretation because I have much more to say. All that I can say is General Assembly could successfully argue that if there are large-scale violations of human rights taking place in the territory of any state, it can deal with those things apart from isolated violations of human rights. That was how it started. Now, in the history of the United Nations Organization, as you see, it provides for human rights, as I have already said. And therefore, the economic and social organization can take these matters and it comes within the domain of that body. Now, on the basis that charter-based protection of human rights came into existence. Now, charter-based protection of human rights would be that through the provisions of the charter and the Universal Declaration of Human Rights, protection of human rights is available to all members of the United Nations Organization. It is not depending upon the treaties, as I said, human rights treaties. Now, for that purpose, Commission on Human Rights was established long back. And the Commission on Human Rights has contributed in a number of ways for the protection and promotion of human rights. In the early period, they participated in the drafting of certain international instruments, and later on, you will find that they also helped, you see, in the promotion of human rights by way of collecting allegations of violations of human rights, and also, you see, trying to see through various ways how best such violations of human rights could be controlled. But one of the greatest drawback of the charter-based protection was that it was only making recommendations. and it could not impose obligations. Now that was how they thought it in terms of treaty-based protection, about which I have already mentioned. It's starting with civil and political rights covenant, international covenant on economic, social, and cultural rights, racial discrimination convention, and so on and so forth. But the point is, the provisions of these conventions will impose obligation. Unlike the charter-based protection, they impose obligation. But they are restricted to those states who are parties to the treaty, who have accepted the treaty, signed the treaty, and ratified the treaty. That is the distinction. But however, you will find number of these human rights conventions have been accepted by most of the states. For example, you have the Child Rights Convention. Within a short period, more than 180 states became parties to the Child Rights Convention. This way, the charter-based protection and the treaty-based protection are being put to work for the purposes of human rights protection. Now, however, when I was speaking about the charter-based protection, the Commission on Human Rights, in the back end of its period, that was somewhere in 2005-2006, it became a politicized body. You see, they were selecting states, they were not giving attention to certain states who were notorious for violations of states. And what is more, some of the greatest violators of human rights, you see, occupied the Commission. Now, therefore, they thought in terms of winding up the Commission on Human Rights, and in its place, in the year 2006, they established the Human Rights Council. Now, Human Rights Council, although there are a number of allegations against it also, you will find the Human Rights Council has one important task that is assigned to it, which is called as Universal Periodic Review. Universal Periodic Review. Now, in the case of Universal Periodic Review, it is a unique process where what is involved is periodic review of human rights records of the members of the United Nations. All states are taken into consideration, and what you will find is that in its process of examination of the human rights records of all the states, you see, it has to complete one cycle, that is all states who are members of the United Nations organization, within a period of 4 years. They have already completed first cycle, they have already completed second cycle, and the third cycle is in progress. That is, they have examined the human rights records of all members of the United Nations organization. In every year, they examined about 48 states. That was how they had completed, and the third cycle is in progress now. Now, at the time of the examination of the human rights records under Universal Periodic Review, they will not only receive reports from the states with regard to situations of human rights in their territories, but also the compilation made by United Nations various bodies. There may be related bodies in the United Nations. It may be World Health Organization and so on and other bodies. They will receive information from them also. And then certain stakeholders also would provide the information, like the non-governmental organization or human rights institutions. They will also provide information. On the basis of that, they will examine the human rights records of all those states. That is how you see, the universal periodic review is made. Now, coming to the treaty-based protection, there are various ways through which they examine the human rights records of those states. Every state, moment it accepts, that is, it becomes a party to the human rights treaties, it is expected to give an initial report, and afterwards they have to provide periodic reports. In the initial report, they should give full information with regard to their constitution, their legislation, particularly emphasizing upon those provisions related to the protection of human rights, and also how the executive works, and also independence of the judiciary, because independence of the judiciary is significant for the reason that if there are violations of human rights which will be considered by the judiciary, then if there is independence only, then it is capable of resolving those disputes impartially. Therefore, what you notice is independence of judiciary. So all this information should be given. Now thereafterwards, periodically, it may be once in 3 years or once in 4 years, depending upon that particular treaty, they have to give full information with regard to situation of human rights. Of course, in the early period, there was some misunderstanding about it, because the states thought in terms of giving a summary report very briefly, and as you know, that no state would accept that violations are taking place within its territory. But however, the committees did not accept those reports. They wanted an elaborate report giving full particulars, and therefore they gave guidelines on the basis of which the reports should be sent. Now the guidelines would indicate that not only the provisions of the Constitution and their laws providing for protection of human rights should be given, but also they should, for example, if it is civil and political rights and a committee, that is what is called as human rights committee, then they have to give, you see, go article by article and provide, suppose if it is Article 5, what is the protection of human rights that it provides for? Then what is the provision of the Constitution or law, you see, which is seeking to protect that right? And how it is implemented, how many violations take place, how those violations have been dealt with either by the executive or the judiciary. Full information should be given. That was how they were able to, you see, do this. But then there was also this difficulty, namely non-governmental organizations cannot officially provide any information, because there is always a conflict between the state and the non-governmental organizations. Although under the Economic and Social Council, you will notice that some status is given to certain non-governmental organizations who satisfy certain requirements, and on the basis of which they can be observers there. Now, however, non-governmental inputs received from the non-governmental organizations are taken by the members of the committee informally, and every state would have been given a particular date on which their reports would be examined, and therefore a representative of that state has to come before the committee. Now, on the date on which the representative would be available, he is expected to brief before the committee about the report. And then also you will see that the members of the human rights committees, various committees, for example, as I said, civil and political rights committee is called as human rights committee. But all other committees are named after that committee, like committee on economic, social and cultural rights, committee on for example, racial discrimination, etc. Now, therefore, on that particular date, when the information or input is received from the non-governmental organization, they will make use of that input while, you see, examining the report and seek further information from the representative of the state. This is how. And many times you will find representatives have been caught napping because they might have given some false information, And therefore, because of this reason, the committee is comprising of experts in the field. And secondly, it has geographical distribution. And therefore, they will be aware of the things that are taking place, how human rights are being protected or violated in the territories of particular states. Now, this is how the treaty-based protection generally works. Now, reporting is one mechanism. Apart from that, there are other mechanisms. Like, for that matter, interstate complaint mechanism. That is, one state which is the party to a human rights convention, if it finds that in the territories of another state who is party to the convention has violated human rights, it can complain to the particular committee with regard to violation of human rights. It is called as interstate complaint mechanism. But unfortunately, interstate complaint mechanism has not been used. And except only recently I found in the paper, the first interstate complaint mechanism has been received, but otherwise it has not been entertained by any state, for this simple reason that every state is a violator of human rights, and therefore if one state complains against the state, it is always at the risk of being complained by other states with regard to violation. That is how it is not working. But the most important thing that has been taking place in the International Human Rights Committee is the individual petition mechanism. Individual petition mechanism is optional, first of all. India has not accepted individual petition mechanism for any of the human rights conventions. But you find number of other states, Sri Lanka, then even Nepal has accepted it. Or for that matter, most of the European countries, they have accepted it. And under the individual petition mechanism, if an individual's human rights is violated, then if he is not able to get redressal within his state, then he can petition to the International Human Rights Committee. Thousands of cases are decided by the committees. Committee allots one particular date in every session for the purposes of entertaining individual petition mechanism, and on that day, they will decide those cases. You will find an array of cases, thousands of cases are decided, which has in fact contributed to the development of jurisprudence of international human rights. Now, there are certain conditions, of course, apart from that. Namely, that first of all, you should have exhausted domestic remedies. That is, what remedies are available within the territory, he should make use of. If after exhausting that he is not able to get satisfaction, that is, justice is not given, then of course he can think in terms of petitioning. No oral petition mechanism is there. It's all written petition. And then the person whose rights are violated alone should approach the committee, that should petition to the committee. But there may be exceptions. Exceptions because it may not be possible for the victim of human rights violation to approach the committee. Like, for that matter, if it is a case of, let us say, false imprisonment. If he is imprisoned, he is not be in a position to himself do. He may not be able to do it, and therefore, his relations or representatives can approach the committee, justifying as to why the victim himself could not do so. So this way, complaints are received by the human rights, all human rights committees. Earlier, they were restricted to few human rights committees only, but now you will find all the core 10 international human rights conventions, they have this mechanism of individual petition mechanism. And then the second, and the other most important condition is that it should not already be, under the consideration of any other international procedure. For example, a person in Europe cannot go to the European Court of Human Rights and also come to the International Committee. He cannot take both advantages of both these things. So he has to choose either of them and restrain himself. Now this is how, the other condition is. Now there are certain other things. The committee has two stages. One is admission stage, the other is merit stage. In the admission stage, they will see what are the applications, such complaints that could be admitted, whether they have exhausted domestic remedies, whether it is not already in the consideration of any other international procedure, whether it is the person whose rights are violated, all this, whether it is, and it should not be abusive in language. You should specifically point out what is the provision that is violated, and it should be with evidence. That is also equally important. You can't say my rights are violated. You have to produce evidence. For example, if I am tortured, there should be a medical certificate. So this way, there should be evidence. If all these conditions are satisfied, and therefore since it is satisfied, the committee admits it, then the merit stage will come. Under the merit stage, they will decide whether such rights were violated in fact, and therefore what should be the remedy. But the most important thing to be remembered is these decisions given by the committees are not called as decisions. They are called as views, because you see there is no compulsion on the part of those states, to give effect to those decisions. That is why it is called views. But however, the statistics, it is said, show that most of the views given by these committees are implemented by the state, provided of course if there is politically sensitive matter and such other things are there, then of course state may not give, but otherwise generally it is given. Now these are the, now also general comment is another important thing. Every session, they devote a particular time for the purpose of general comment. General comment would be they take certain provisions of each convention and elaborate it. What is the meaning of it? How it should be interpreted, so that the states who are parties to that particular treaty, will give those interpretations to the provisions of the convention. They cannot do. They cannot put it in. Rather, they cannot use it in any other way. It has to be done in the way in which the committee has interpreted it. Committee has given all the committees. They are giving, most of these committees are giving under their general comments. They have elaborated with regard to the terms that are used in the convention, which is called as general comment. Now, application of human rights standards becomes the most important thing. Now, what I mean by application of human rights standards. Now, all these human rights instruments, they create standards of human rights. If you go through the provisions of a Universal Declaration of Human Rights, if you go through the provisions of the Civil and Political Rights Convention and other human rights, they have provided as to how the human rights should be protected, what are all the human rights. And even with regard to restrictions, how restrictions should be laid. Now this becomes a set of standards, and therefore every state which becomes party to the human rights treaties should look to, should try to see that these standards are maintained in their legislation also. Now, for example, if you impose restriction upon freedom of speech and expression, what are the restrictions that you may impose? It may be that respect for others. This is one of the most important things on the basis of which restrictions could be imposed. That is, if in your speech you are trying to, violate the respect of others, then of course a restriction might be imposed. That is one thing. So restriction is one important thing. Secondly, while laying down the standards, what also these committees have insisted upon is the test of necessity and proportionality. That is it necessary that when you impose certain restriction, is it necessary to impose restriction? Then proportionality means to what extent you can impose restriction. Now, there are a number of decisions given by these various committees on this test of necessity and also proportionality. They are very, very important because if you are not in a position to maintain the human rights standards as laid down by proportionality and necessity test, then you are violating human rights. You may be imposing a restriction, let us say on freedom of speech and expression, and that may be keeping in you to give respect to others. But to what extent you can impose restriction? Is it necessary? These are the two most important tests that should be applied under the application. Then the measurement of human rights is an important development that has taken place, you see, in the contemporary period. Now the committees found that human rights are violated, and they come to the conclusion that human rights are violated. But to what extent human rights are violated? Should it be very subjective? Should not there be an objective way of determining the exact extent to which human rights are violated? Now, that is how the measurement of human rights formula is being adopted under what you call as indicators of human rights. Indicators is scientifically measuring, the compliance with human rights, and also whether violation has taken place, could also be measured by indicators. It is a statistical way of determining the violation or compliance with the human rights, and that is how the measurement of human rights also takes place. Now, under the limitation, there will be restriction, there is derogation and non-derogation of human rights. Now, when I speak of restriction on human rights, as I was already pointing out, certain restrictions are already there, which are provided for in the conventions on human rights. Therefore, you cannot restrict human rights on the basis of any other, reasons or causes. You should confine yourself to those matters as are pointed out, or as are laid down, or as provided for in the convention itself. Now, for example, I will in one of the cases, that is Celebrity versus Uruguay, State of Uruguay, CELIBERTI, Celebrity versus Uruguay, which was decided in the year 1981. Human Rights Committee decided this case. Now here, a Uruguayan was kidnapped in Brazil by Uruguayan agents, and he was brought to Uruguay. That is, he was abducted in a secret way, and he was arrested, detained for violation of certain provisions of the Human Rights or Civil and Political Rights Covenant. Now, the committee found that under Article 5 of the Covenant, that is, Article 5 of the Covenant prevented a state from relying on Article 2.1, that is, to escape responsibility for acts perpetrated by its agent on foreign soil. The point is whether human rights conventions are imposing obligation upon states for violations of human rights taking place only within their territories or even outside the territory. That was what was the consideration. Now here, if human rights violations have taken place outside their territory, am I responsible? I can do anything, was one of the ways in which it was argued. But the committee did not accept it, because it is an obligation upon that state not to violate, and therefore, whether it is within the territory or outside the territory, it equally holds good, and that was how it was said. in the celebrities case that the state had violated, you see, the provisions of the Covenant on Civil and Political Rights. Now there are a number of such cases decided. For example, in Purna, Maya versus Nepal, even Nepal is a part, has accepted individual petition mechanism. Now here, Human Rights Committee was examining inter alia issues relating to Article 3. Article 3 refers to equal rights of men and women. And Article 26, that is non-discrimination on the basis of gender. Now the petitioner was a national of Nepal. She claimed to be a victim of physical and psychological torture in violation of Article 7 of the Covenant. As a result of the acts she was subjected to, including blindfolding, beating, kicking, punching, and gangling, which were inflicted on her for a number of reasons, including to extract information, to punish her for something that her husband had allegedly done. Her husband was a Marxist. He was not available, and therefore they caught her, his wife, and they were trying to inflict all these kinds of violations upon her. Now here, she was also rejected by the society because she was living in a society which was highly traditional, and since she was gang raped, she was isolated from the society also. The petitioner claimed to be a victim of discrimination on the grounds of gender. Then, of course, that is also, you will find number of other rights of her, as I said, were violated. And the committee pointed out, now the entire point was this is an important jurisprudence laid down by the committee. She was not in a position to provide appropriate evidence because it was not available with her. Now what the committee said, and that is a remarkable statement made by the committee observed that in the light of the petitioner's detailed, consistent description of the gang rape and other acts of torture endured, which are corroborated by medical and psychological reports provided by her and coinciding with the general pattern of violations committed by Nepalese security forces during the internal conflict as documented in various intergovernmental and non-governmental reports, including in particular sexual violence against women suspected of being Mois or Mois supporters in the context of interrogations and in the absence of any explanation from the state party in this respect, due weight must be given to the author's allegations and it amounted to violation of Article 7. Now here the committee pointed out that the burden of proof need not always rest on the petitioner alone, especially in view of the fact that the state party had a better access to information than the petitioner. So even though the petitioner was not in a position to produce proper evidence, she was only in a position to give some evidence. But the court said, but the committee said that we cannot expect under these circumstances this woman to produce all the evidence. So if the state's argument is it has not violated, that should produce evidence. And it is not for the victim to produce evidence under these circumstances, was the opinion given by the committee. Now, this way, I cannot go into all those decisions given by the various committees, and that is how it is. Now, there are derogation of human rights and non-derogation. I can only make a very general comment on that. Derogation of human rights is provided also in Article 4 of the Civil and Political Rights Covenant. That is, during the period of emergency, every state would like to have more powers. That is, to intervene more. That is, in respect to the human rights enjoyed by the people. they have justification because it is an emergency situation. It may be external aggression, internal disturbance, or natural disaster. These are the three situations contemplated. Now, however, under Article 4, certain restrictions are imposed. Under what circumstances you can say that there is what is called as such a situation. How it should be handled, namely you should make a proclamation. Then you should also announce beforehand what are the human rights that you are going to derogate from. And there are also what are called as non-derogable rights. You cannot touch those rights. Whatever may be the situation of emergency, like right to life for that matter. You can't touch that. So this way, derogable and non-derogable rights are also provided. Now, this is how you see the entire thing works. Now, obligations are there upon all states who are parties to these conventions. It is a duty imposed upon them. Now, there are three kinds of obligations that are imposed. Obligation to respect. Obligation to respect would mean not to interfere with the enjoyment of human rights. These are obligations upon the state. State should not interfere with the enjoyment of human rights. It is a negative obligation. Then obligation to protect. Obligation to protect means parties are compelled to take measures so that non-state actors, whether individuals or groups, including corporations and other entities also would not violate. That means obligation to protect means within their territory, no violation should take place. Which would mean, you see, it is not only state, but even other entities should not violate the human rights. Because the obligation is to see protection of human rights within the territory, whoever may be the violator. Then obligation to fulfill is the third kind of obligation. Obligation to fulfill means they should adopt appropriate legislative, administrative, judicial and other measures to realize human rights. For example, it is for the purposes of promoting human rights or protecting human rights, state itself might have to help, you see, the people for the protection. For example, right to education. Right to education. State itself should help. So that is what is called as the obligation to fulfill. Now these are the three kinds of obligation. And the next thing is about the Indian scenario. I don't think the time would permit me to go through it in detail, but especially Articles 51 and 253, you please refer to Article 51 and 253 of our Constitution, where international obligation is upon that. Although it is provided, it is the directive principles of state policy, especially Article 51. It does not mean that the state can overlook its international obligation. There is another important aspect that should also be noted. Now that is because if you go to the provisions of, for two reasons. Number one, if you go to the provisions of directive principles of state policy, it is an obligation imposed upon the states in its governance, and therefore states will have to take it seriously. Secondly, if you go to the jurisprudence of our own Supreme Court, you see nowadays what has happened. If you look to the directive principles of state policy, you see have their own life. You see they impose a kind of an obligation upon state, and wherever states are failed to give effect to the provisions of the directive principles of state policy, the Supreme Court has held that it has to be read through Part 3 of the Constitution. And they have done it in number of ways, like right to education under Article 21, because right to education was not there earlier in the fundamental right. But even before that, Supreme Court held, you see, it is right to life, right to healthy environment, right to health, and now right to water. You see, the United Nations organization has been able to, the General Assembly has passed a resolution, Human Rights Council has accepted that right to water is a human right. So this way, you will find that number of these rights are provided for, and although you see some of these rights are in Part 3 of the Constitution, and some of the rights are indirectly principles of state policy, it should not be taken to mean that what is in Part 3 of the Constitution is must and not what is in Part 4. Although what is in Part 4 may not be justiciable, that should not be taken to mean that state has no obligation. Equally, it is an obligation on the part of the state because the Constitution provides so. And secondly, and most importantly, by becoming a party to the various human rights instruments, it has accepted that obligation. Because under international law, if any violation of an obligation, international obligation, would entail state responsibility. State responsibility is something liability in municipal law. It entails a state responsibility, and therefore every state is expected to conform to those standards as laid down in international human rights instruments once it accepts those provisions of the Constitution. Now, of course, I tried to summarize everything, but I know that in the process of summarizing, many times it will end up in hodgepodge, you see. And however, I have tried to make it as organized as possible because it is a vast area. It is a vast area. Recently, you see, for this online course in UGC, I prepared an international parameters, but it went to 110 pages. You see, it is a vast area, international human rights law, and it is a very, very developing area. It is a very developed area, and it is a developing area. When I look through these development in international human rights, many times I find the jurisprudence of international human rights law has so much developed that the development in municipal law is still to pick up, is still to come to that level. So much it has. For example, right now I am concentrating upon protection of that is human right to protection of privacy in international law. Right to privacy in international law in the digital age, for example. Lot of developments are taking place. There are special rapporteurs appointed for this purpose, and lot of work is being done. So this way, international human rights law is a vast area. And every state, you see, because they are members of the United Nations organization, and also in many areas they have accepted or they have become parties to the human rights treaties, there is an obligation upon them to conform to those international standards. Therefore, the provisions of the Constitution, you see, that is how, when our Constitution was drafted, Universal Declaration of Human Rights was available to them. Universal Declaration of Human Rights was a resolution passed in the year 1948, and Constituent Assembly was very much there at that time. They had access to these provisions of the Universal Declaration of Human Rights. That was how, in Part 3 and Part 4, the provisions of the Universal Declaration of Human Rights were taken and imbibed in our Constitution. So you will find that the Constitution, you see, when you go to the Constitution, you see, there is an obligation upon every, not only Indian Constitution I am talking, all over the world, every Constitution, you see, they have an obligation to see that either in the provisions of the Constitution or in their laws, they should provide for human rights. That is, those are human rights parameters or international standards of human rights which should be implemented. Now, I thank you very much for having given me the opportunity to speak. I don't know whether we have any questions. If you have any questions.
Sir, you said there are obligations to protect. So, what happens when a country or a state breaches its obligations? And how?
No, there is violation of obligation. There is violation of obligation, but the system of international law, you see, has its own problems. Unlike state law, you see, it has no mechanism to implement that. That is always there. That is always there. But it has violated. But there are other ways of dealing with that. You see, like for that matter, imposing sanctions, etc. There are other methods. Therefore, there is violation. There is violation.
So will that lead to sanctions?
Pardon?
So will that lead to sanctions?
No, imposing sanction is not so easy. You see, it is only United Nations which can do it. But United Nations is a political body. Human rights committees are legal bodies. So when it comes to political bodies, they take political decisions. So sometimes they may take cognizance of those things, sometimes they may not. So that is how it happens. But there is violation.
When it comes to big powers, international shaming is the only possible deterrent as of now.
Part of international shame.
Shaming, yeah.
That is the only deterrent.
Like,
Shaming is an important aspect, I understand. But then, what you also notice is that isolation, you see, because of that, is also an equally important. For example, what is now happening to Pakistan? Isolation. Isolation is a very important aspect to be considered because no state is an island. It has to depend upon other states. Either, even if it has surplus things, it has to depend because it has to sell those things. Even United States are kept in isolation. Now, the isolation is an important aspect to be considered in the present context. So that is how it has to work. But always, even violations of municipal takes place. You cannot help it. Violation takes place. But much depends upon how best you can resolve those things through negotiations, through arbitration, conciliation. These are the various modes through which these things could be resolved. There's a better way of resolving it, especially in international law, because what is required is peaceful coexistence.
So in case when one of the big five countries themselves are violating human rights, what is the solution to that?
What is the?
What is the way to overcome it? When one of the big five countries in the Security Council themselves are violating human rights? Five.
Oh, you are talking about Security Council?
Yes.
No. You see, I don't know what exactly is the purpose of the question, but if you go to the historical background, that is very important. See, in the League of Provisions of the League of Nations Covenant, it was not there. Now, what they thought was at the time of drafting the Charter of the United Nations Organization, that any important decision should not be taken without consulting strong powers. You see, because it would be dangerous. That was how it happened. The calamity took place during the period of Second World War, and therefore you should consult important and strong states. Then only you should take important decisions. That was how you see the veto was provided in the Charter of the United Nations Security Council. You see 5 powers, but these 5 powers, which were then considered as most important and powerful states, some of them are not so powerful today. But how are you going to remove them? You see, nobody is prepared to sign his own death warrant. You see, that is how it is. So you can't, because it has to be with their consent. You can't remove them. But it has become very difficult even to put somebody else also in their place because they don't like, you see, to their monopoly to be taken away. That is the difficulty, but we don't know. There may be, you see, lots of progress that will take place, consultations will take place, negotiations and such things. And therefore they may be able to include 1 or 2 more states, like India is also one of the contenders. But how far it will be successful is something unknown today. If that is what your question is. Yes?
Yes, sir.
Okay, thank you all.